Hey folks, welcome to this week's Lawfare Live. Uh, the tribulations and trials of the Trump administration. I am here with the estimable James Pearce, Roger Parloff, and Anna Bauer. Hi, all.
Hey
Hello.
Ben,
We're going to jump right in because there is so much going on that just getting through it today is going to be a challenge. First of all, James, we got breaking news. Kilmar Abrego Garcia is coming back to the United States to face a criminal indictment. Um, uh, this is, I suppose, compliance with Judge Sini's order, but in a fashion maximally Steve Millery. What do we know? What's he being charged with? And what can we say about the indictment?
Yeah, so this looks an awful lot like facilitation through extradition. And what we have, as you said, is an indictment in the Middle District of Tennessee. That's essentially the Nashville area. And it is a two-count indictment that charges Kilmar Abrego Garcia with conspiracy to knowingly smuggle aliens, and then one substantive count as well. And so what it appears in the 10-page indictment that has just been made public, according to reporting, the actual indictment happened at some point last month and then was just recently unsealed. So this is apparently, and in fact, at the bottom of the indictment it says May 21st, 2025. So that's how long this indictment has been on the book, so to speak. So what the indictment seems to lay out, so notably, it alleges that Kilmar Abrego Garcia is a member of MS-13. That's not a surprise that it would be alleged. Certainly, that was what the administration has consistently said. This moves forward to a trial. Perhaps that will be proved or not. It's not an element of the actual offense here, but it is certainly something that the U.S. Attorney's Office, that the government saw fit to put into the indictment. The thrust of the indictment is essentially that Kilmar Abrego Garcia, working with others, and I should mention there are five co-conspirators, all just named CC 1 through 5, not unusual in a federal indictment. Some of the reporting, I think, from ABC News has identified one individual who perhaps is one of those co-conspirators. I don't remember the gentleman's name, but at least according to the reporting, it was someone who himself is serving time for, I think, perhaps a legal reentry, and whose car, according to the reporting, I didn't see this in my quick skim of the indictment, Abrego Garcia could have been using. The indictment alleges a conspiracy from 2016 to 2025, and basically says that Abrego Garcia, with others, picked individuals up in Texas and then transported them throughout the country. Again, unlawful individuals, did it as part of his work with MS-13. And these were folks that were coming through essentially Central America and Mexico to cross the border unlawfully into the United States. And again, there's the conspiracy charge that has all the other individuals, and then there's a single substantive count for November of 2022. Interestingly, as I read the kind of the manner and means, or sort of what the indictment calls transportation in Tennessee, looks like all of the allegations are on that November 2022, notwithstanding the much broader alleged conspiracy of 2016 to 2025. So that's the quick and dirty on the few minutes that the indictment has been out.
All right, so help me out. When I see the word facilitate, I don't usually mentally translate to the be indict. Um, and on the other hand, Judge Sini's did her order is that they facilitate his return to the United States. Um, this will do that, I suppose. Um, and I assume that the reason that the discovery in that case has been, uh, slowed to a crawl and we haven't had any rulings, right, is because they have made her aware that this process was ongoing and that it would presumably satisfy her order once completed. Is that a fair assumption, or do you suspect otherwise?
Yeah, and I'll take a crack at answering this, and then perhaps either Anna or Roger, who I know have been following kind of the immigration proceedings or the mistaken removal proceedings. I suspect that assumption is correct. We don't know, and at some point we may or we may not, but I do think that it is a fair reading of the order to say that the requirement on the government was to facilitate his return. I don't think this is what he would have expected, but if he is in fact extradited under this criminal indictment, his return to the United States will have been facilitated, and then presumably he will face the same criminal justice process that any indicted defendant in the federal system will. And so whether the pause or the sort of seemingly from the outside mysterious continuing of the deadlines in the matter before Judge Sinis has this to account for it? I would think so, but I don't have any inside information. Perhaps either Anna or Roger does, but that seems to me the most rational explanation for it.
Anna, Roger, do either of you have a sense of what role this indictment, which has been pending for 2 weeks now, played in the litigation in Baltimore or in Greenbelt? What do we know about the interaction between the civil litigation and the criminal case?
We don't know anything, but I think we maybe 1 week of the delay might have related to this investigation, and the government wanted more delay. They kept saying that they were working on something that might solve the problem. So maybe that was it. I think the rest of the delay has been, conventional discovery privileges, state secrets, and that sort of litigation.
All right. I want to
Uh,
ask the question that everybody is thinking about right now, which is how suspicious we should be of this indictment. On the one hand, the government has said from the beginning, this guy's MS-13, uh, and, it was not an accident that he was rolled up, even though they said it was an accident that he was rolled up, and bad guy. And we've seen this in terrorist contexts where people go from civil liberties victims to, oh, the guy that you were holding, the American citizen being held in Saudi Arabia, that the United States wasn't doing a whole lot to get back. Turns out we're indicting him for a plot to assassinate President Bush, right? And so, on the one hand, I hold in the possibility that this is a clever resolution to a sticky problem. On the other hand, maybe this concedes my bias here. I'm not instinctively giving a presumption of regularity to this indictment. I look at it and I say, boy, it's really convenient. This guy's been living here for a long time, free man. Anytime prosecutors in Tennessee wanted to bring a human trafficking case against him, they could have done it. They waited until he was a cause celeb for being shipped off to the gulag in El Salvador, and U.S. senators care about him. Um, I will wait until this is proven in a court of law, and this is one of those situations where it's worth taking the presumption of innocence very, very seriously. What do you guys think? I mean, do you look at this and say, hey, federal prosecutors generally don't bring shit cases. He's like, let's afford a presumption of regularity to the justice system? Or do you look at this and say, yeah, prove it to a jury of 12 people beyond a reasonable doubt, and then we'll talk?
I I can jump in here because I find myself torn, which is I spent 11 years as a federal prosecutor. I have been in front of many grand juries, notwithstanding the old saw that you could indict a ham sandwich, I think that going in front of a grand jury and eliciting your evidence and building a case is a serious matter, and is one that serious Justice Department prosecutors take and understand the gravitas of, and act accordingly. That said, it has been very dispiriting to see everything that has happened in the, whatever it is, 4 months or so, that 5 months that we have been under the Trump administration. And, I think Lawfare has written, and others have certainly also echoed. I think I saw something in the chat that says, look, the presumption of regularity with which we typically expect the government to operate really seems not to exist, and courts have pushed back on it, and the public has pushed back on it, and so I think I would put myself in the latter camp of the two, kind of that being the one of I'm quite, I don't want to say suspicious, but it does strike me as all too convenient to have moved to indict this individual at this point, and notwithstanding allegations that reach all the way back to 2016.
What do you think, Roger and Anna?
Well, I think I'll take a posture of trust but verify. This incident occurred 3 or 4 years ago, and he was not even given a ticket at the time. So obviously there's that, but I just don't know the facts. The other thing that, and we're going to speak to that in a moment, is that they've been saying we can't get him back. We have no control over what they do in El Salvador, and then they get a story that they like. Or maybe, I don't know if we have an extradition treaty, but suddenly he's coming back. So, there's that too. Anna?
Yeah, I mean, look, I'm not going to say anything that I think others haven't already said. I will say, I think when I was in law school, I planned to be a criminal defense attorney and a public defender before I met Ben Wittes, and became a legal reporter instead. And so I think that in general, my posture is a little bit more skeptical of prosecutorial power than maybe James has, as someone who has been a prosecutor. But I do agree certainly with him that things that we've seen over the past few months. I mean, at one point I even posted on something to the effect of throw the presumption of regularity in the trash, and as a kind of a joke, but also not, because I think that everything that we have seen points to the idea that these presumptions of good faith that we usually place in federal prosecutors in particular really just has kind of gone out the window. I also will add, though, that this indictment came out right before, we just got our hands on it right before we came into this podcast recording. So I would like to have more time to look at it and study the facts. I just haven't had a chance to do that in detail yet. And so we will see. Judgment is out.
Yeah, I think
That's
that
a
is
good
wise.
point.
It is wise for everybody to keep an open mind. This is something that did have to go through a grand jury. It is something that will have to be proven in court beyond a reasonable doubt. And I will also say that, Mr. Abrego Garcia, there is one actually very good side of this for him, which is, other than not being in El Salvador anymore, but he, presumably you will have a prompt bail hearing. And I think that is something that has been missing from a bunch of these cases. And one thing the criminal justice system, unlike the immigration system, has is a reasonably prompt approach to bail. And I do think that is worth something on for him. All right. Let us turn to the other case involving people who were shipped off in violation of a court order to El Salvador and who are, unlike Kilmar Abrego Garcia, not coming back to face indictment. This is the J.G.G case in which we have had substantial developments. Roger, what's going on?
Yeah, I think this is pretty important. It was a nominal success for the ACLU, but I'm concerned about it in the long term. This was Judge Boasberg did certify a class composed of all of the people that were sent to CECOT on March 15th under the Alien Enemies Act proclamation. So that's about 140 people, 137. And he also is going forward with the case in DC, and he ordered, he found, which is not surprising, that they weren't accorded due process. These people weren't accorded any due process. I mean, they weren't given notice. They weren't told where you're going. You know, they were begging, pleading, crying, praying, and they said, we can't, we're not telling you, and they get on the plane and so on. And in fact, that's why he frames it with references to Kafka's The Trial. But I thought that if Judge Boasberg went forward with the case, he would find constructive custody. That was the big issue. You can't, this is a habeas corpus, and so does anyone in the U.S. still have any custody over the prisoners? And the government was saying no. And he says that the plaintiffs, on balance, though it's a close question, they have not shown constructive custody. And he was obviously uncomfortable with that, but government had submitted an affidavit, since it goes contrary to a lot of public statements, like Trump saying, I could bring him back with a phone call. And and all the statements about, a renewable contract and outsourcing and so on. But a guy named Michael Kozak, a high-level State Department guy, put in an affidavit that said, once there, we don't know, it's redacted, heavily redacted, but Boasberg has seen the whole thing, obviously, and it says in essence that once they're over there, it's ultimately his call. It's Bukele's call that we don't have any, and the best evidence of that was that Bukele had announced that he ostensibly that he was negotiating a deal with Venezuela where he would send 252 people from CECOT to Venezuelans, and they would send back 252 Salvadorans. So he said, on balance, he had to take, even with all the misconduct, he had to take the government's word based on the precedents. And he did say he recognized this might be a ruse and it might be a fraud. And if it turned out to be, he would not be happy. He would take steps. He also warned the government about the perjury statute, but that's where it is. So, and then.
But explain something to me, Roger, because I'm mystified by this. If there's no constructive custody, why is there a case at all?
Well, that's the next part, and that's what makes me uncomfortable. His workaround is he says, and I guess the ACLU must have briefed this too. I can't remember, but he's going to call it this is a case about due process. It's directly under the Fifth Amendment. The federal due process is said to come through. It comes through the due process clause, the Fifth Amendment, and because the defendants are not seeking release, they're seeking process. They're seeking an opportunity to show that they're not tren de Aragua. And they're also trying to show that the proclamation's invalid. But so it doesn't necessarily lead to their release. But he makes an argument that's strong in itself, but the problem is that the Supreme Court sort of already rejected an argument that sounded almost identical to that in this case. You know, the last time around, he was entertaining a class action on the theory of that it was under the APA, Administrative Procedure Act, and they pretty much said, no, if you're challenging the AEA, you need to do it under habeas. So that's one problem. The other problem I'm concerned about is the issue of redressability. You know, if you're saying that the government, these defendants don't have constructive custody, then how are you ordering them to do anything? And that's sort of I think that falls under the standing rubric, but a case or controversy rubric if you're, you know, if you can't do anything to help the person, it's sort of an advisory opinion almost. So those are pretty serious problems. And then it also impacts all the other people who are trying to get people home from CECOT or from other El Salvador prisons, of which there are quite a few now. And I thought that would include Abrego Garcia, but it includes Christian, you know, the guy in the other Maryland court. And there's now 2 guys out of Georgia. So it's a troubling ruling.
And I take it is not at this point appealable, right? Because it's not an order of, it's not dispositive of anything.
That sounds right. All he's done so far, well, no, I don't know. He ordered the government at this stage to take the first stab at proposing how to provide habeas corpus rights to the people in CECOT. And I anticipate their response being, how could we do that? You just said we don't have custody. And where it goes from there, I can't exactly, I can't extrapolate. Maybe somebody else can.
All right, we are going to shift gears from people who were locked up in El Salvador.
I just want to give Catherine Falders a shout out. She's the ABC reporter. That's a pretty big scoop, so we should credit her.
Excellent. We are going to shift gears from people who were locked up in El Salvador to universities that are locked up in Cambridge, Massachusetts. I'm going to turn the moderation duties over to Roger here because the person who's been following this case is me.
Yeah, so I understand there was a new executive order issued this week. Can you tell us a little about it, Ben?
Yeah, so this one came as a bit of a surprise to me. I shouldn't have been surprised by it because I've spent a lot of quality time with the law that it is issued under, which is 8 U.S.C. 1812 F. Some of you may remember that statute because it's the statute that gave rise to the travel ban in the first Trump administration and its many iterations. And it says that the president can designate any class of aliens and forbid their entry or suspend their entry into the United States. And usually we use this for like people interdicted on the high seas or people in Russia who are, killing Ukrainians, or people, in the case of the travel ban, people from 8 countries that I don't like, right? But Trump did something really weird and a little bit clever with it, which is he defined the class of people not by anything that they had done overseas or that they, that were features of who they were or something like that, but according to their desire to attend Harvard University. And he said, okay, you're stopping me from giving grants to Harvard, preventing Harvard from getting its grants. You're stopping me from decertifying it for foreign students, but you can't force me to admit foreign students to the country. And so he issues this proclamation that says basically suspending entry of aliens who are intending to enroll in Harvard University. And it's a little bit of a puzzle. Harvard went into court and got a very quick temporary restraining order. And it's a complicated little case, and I have to say, whoever, whichever of the like harass Harvard University team came up with this one, it's kind of like I don't approve of your vocation, but it's a slightly clever one for reasons we can go into.
And is that, oh, I see. That's, well, maybe that does it with the attacks on university.
Yeah, I mean,
Can you tell? I'm curious, Ben, why it's so clever. And also, I hope it's not another one of my former classmates who is in charge of the Destroy Harvard University team.
I mean, that would be, the ultimate way to put your middle finger up to your law school would be to prevent it from admitting students. So the cleverness arises from the fact that Congress has essentially plenary power over admissions of people. And the power of Congress over the border is enormous. And the delegation in 1812 F is super, super broad. So John Roberts, in one of the travel ban cases, wrote that it exudes deference to the president. This is not one of those statutes about which how much deference they get is debatable. It's an extremely deferential statute. And so, and moreover, the administration can argue, although I don't think very credibly, that, they didn't really take an action against Harvard University here. They're merely refusing entry to people at the border, which is their prerogative and something that a court has no authority to review under a 1972 case called Kleindienst v. Mandel, which interestingly involved a guy who wanted to come to the United States to give a lecture at universities, and the plaintiffs were people who wanted to hear his lecture. And so, the Supreme Court said in response, we're not even going to consider the First Amendment implications for those people because the consular decision not to admit somebody is unreviewable. And so there's actually some uh, really good, like pretty strong law on the side of the administration here. And that said, the argument that they're making is exceptionally dangerous because if you accept it, why couldn't the administration say, we're issuing a proclamation that's denying Elon Musk is on the outs now. So anybody who has an H-1B visa to work for SpaceX, no entry. Or how about, anybody who reads the New York Times?
But but Ben, what somebody could say, I mean, I mean, they aren't really, the law is supposed to, you can suspend somebody's entry if you think they're detrimental to the interests of the U.S. But as you said, they aren't suspending anyone's entry. They can all come in if they go to a different school, and they aren't even declaring the person detrimental.
That's
only
right. And that's the counter argument is this is a little too clever by half, because in fact the statute says you can restrict the entrance of aliens or a class of aliens, um, but this actually doesn't do that, because all the individual alien has to do in order to circumvent this order is enroll at Columbia. And so it may be a completely, Harvard got the TRO right away. And so I'm not at all confident that the administration prevails on this, and very much hope they don't. But I do think, unlike unlike the law firm cases and some of the other Harvard cases, there is the administration has one very strong statute, and one very strong Supreme Court opinion that it's going to be able to work with in defending this action.
Okay, I think I can hand the moderating duties right back to you.
All right. Well, James and Anna, the other attack on Harvard is on the law review. What's going on there?
I can jump in, and then Anna can add
Yeah,
or correct.
We can go through this one quickly.
Yeah, it's pretty quick. It was sort of surprising news that dropped, I think, the beginning of this week, which was basically that news came out that the administration is undertaking an investigation of the law review for discrimination, and has essentially someone like a cooperator who was on the Harvard Law Review, if I've read the news correctly, and then joined the administration within maybe certainly the past month, possibly even the past few weeks. The thrust of the allegation.
Classmate, Anna?
Yeah, another classmate, perhaps.
Yes, but not someone that I knew, like wasn't in my.
We know who this person is.
We know who this person is. Oh gosh, why am I blanking on his name?
I think it's Daniel Wasserman.
Yes, maybe? Daniel Wasserman. I was thinking it was Andrew Wasserman, but yes, Daniel Wasserman. He just graduated within the past. Harvard's HLS they just had their graduation in May, and so he just graduated, and then now is at the White House working for Stephen Miller.
Yeah, and from the reporting, it sounded like he graduated, and 2 or 3 days later, he was on staff with Stephen Miller and working to bring a legal action against the Harvard Law Review, which, as some folks may know, and his reporting has made clear, is actually neither a part of Harvard Law School nor Harvard University. Is its own standalone entity, and it's not quite clear where this stands or where this is going, but it was at least extraordinary to me. Maybe it shouldn't be, that the administration is sort of among the many tendrils toward Harvard University includes this effort at rooting out discrimination. So the claim, I'm not sure we said that, was that there was discrimination against white males in the selection of I think, articles and potentially leadership positions within the law review. There was at least some cooperation from the law review, though where things stand precisely was not clear, though Anna may have more information.
Yeah, well, one thing that I will just mention that I think is, in terms of, insofar as we've discussed the politicization or weaponization of Justice Department functions, what was really remarkable about this whole ordeal to me is that there's this exchange of letters that the Justice Department is sending to the Harvard Law Review about, this claim that it's making about discrimination and all that. It has this cooperating witness, Daniel Wasserman, and at one point before the HLR apparently knew that this guy was, a cooperating witness, according to the Justice Department, they instigated some kind of disciplinary review process because of it relates to basically someone potentially taking documents and then disseminating them outside of HLR, which apparently was a violation of HLR policies. That led to a revelation, according to the New York Times, that this cooperating witness had downloaded a bunch of files that apparently, was a violation of HLR's policies. He had a reprimand in his file as a result of this kind of review of these actions. And the Justice Department, in one of the letters that it sent to HLR, said, by the time this guy graduates, you must retract or withdraw any reprimand that you have given this guy, which is such a level of, meddling and micromanaging in this internal bodies or this external bodies affairs, that it just was really remarkable to me that this is what the Justice Department was demanding. I have not reviewed the actual text of these documents because I don't have them. They were just reported on at the time, so I don't know the full context. But, insofar as we have been discussing examples of things that are just really far outside of what the normal Justice Department actions are, this strikes me as a really good example of that.
Yeah, keeping the world safe for white men at the Harvard Law Review. This is why we have a Justice Department, people.
And
all right.
Do you know if the Harvard Law Review gets any federal funds?
Yeah, so this is a good question, Roger, and this is something I've been meaning to look into, and maybe I'll do this weekend in terms of because I have a loose sense of what HLR's relationship is to the university. Like, there are some ways that the university facilitates things like the HLR competition. They obviously have a very close relationship with HLR, but I don't know the exact kind of legal status that HLR has in relation to the university, and then any funds that the university receives from the federal government. So stay tuned on that, folks, because that's something that we certainly intend to look into. And if anyone has recommendations or insight on that, then feel free to email me or send me a DM.
All right. Let us move on to how much of the federal government you can fire. James, give us an update on the personnel cases.
Sure. I think there are two cases we wanted to flag for people this week. The first is one that has been kicking around for a while, and it stems pretty much from a executive order that was issued in, I want to say, the 11th of February that directed agencies and was subsequently codified, I think, in that codified is not quite the right word, but through an OMB memo was additionally then transmitted to several agencies, I think 19 in total, essentially directing those agencies to engage in widespread reductions in force or RIFs. That led then to a challenge from various plaintiffs, including labor unions, state governments, advocacy organizations in the Northern District of California. And the district court there first issued a TRO and then a preliminary injunction. The government appealed. There was a little bit of procedural jousting that's sort of beside the point for our purposes. But the long and short is on a stay pending appeal after the Ninth Circuit at the end of last week denied the government's efforts to stay the district court's enjoining of the RIFs. The government went at the beginning of this week, the Solicitor General's office went to the Supreme Court and has sought the Supreme Court's intervention making arguments that we've seen in some of the other cases, essentially things like the district court shouldn't actually, there's not a case for the court to rule on, either because this matter should be in front of the Merit Systems Protection Board, and it was a different statutory scheme under the Civil Service Reform Act, or that there's no viable cause of action. And then, by the way, on the merits, the government argues the president has long had the power to order reductions in force. It doesn't actually have to flow from a particular statute that is inherent in his Article 2 abilities. Interestingly, at least for me, the government's filing a couple of times cites Nixon versus Fitzgerald, which some folks may remember is the case that held that presidents are immune from civil liability, and was much talked about in the case, the Trump immunity case litigated last summer and much of last year. What folks may not remember is that the core issue there was a civilian member of the Air Force who was fired essentially through a reduction in force. And he argued, look, this reduction in force was just an effort to retaliate against me. So the long and short of that is the government has been citing Nixon v. Fitzgerald, and has, in addition to citing Nixon v. Fitzgerald, in a tactic that we've seen elsewhere, the government's filing invokes the practice of the Clinton administration. In other words, trying to say, look, what this administration is doing is actually no different than what other past administrations of different political colors have done. So we'll see. That was filed, I think, on Monday of this week. Justice Kagan ordered a response June 9th. I think that's Monday of next week. But yet again, up on the Supreme Court's emergency docket is one of these cases involving these mass reductions in force. So that's case number one. Case number two is a little bit different than what we've talked about, and was not actually filed within the past year, but has a ruling and reasoning that is quite interesting for cases that we have been following. So this is a case out of the Fourth Circuit that is the Executive Office of Immigration Review versus Owens. Essentially, it was a group of immigration judges who were trying to challenge, or were challenging, a policy that required them to get approval anytime that they wanted to speak in their personal capacity, whether it's at a conference or in some kind of public setting. And so they were challenging and saying, look, under the First Amendment, we should be able to speak freely. And the government came back and responded, this is not, and they had filed that in federal district court, I think the Eastern District of Virginia. And the judge overseeing it said, well, this isn't actually a claim that should be here in federal district court. This really ought to be in front of the Merit Systems Protection Board. So this all happened in I believe, late 2023, argued in 2024, toward the end of the year, I think after the election, but obviously before the new administration had come in. This week, we got an order from the Fourth Circuit that basically said, we think the district court's probably right that Congress meant for these types of claims to go to the MSPB. But we're concerned that when Congress made that decision, it had in mind an actually functioning, operable MSPB system. And what it didn't imagine was something where the Office of Special Counsel would be fired. The MSPB would have members who were removed and thus not have a quorum. And so, essentially one of these presumption of regularity issues, sent it back for the district court to engage in fact-finding to determine whether, in light of all these things that have happened recently, this case should nonetheless be required to go through the MSPB proceeding. So we'll see what the district court there does with it, but very interesting. And I went back, this was essentially sua sponte by the Fourth Circuit. So they hadn't sought additional briefing on it. They sort of took notice of the public record and then issued this ruling. So we'll be curious to see where it goes, but certainly an interesting commentary, and the fact that, hey, judges live out in the world and are aware of what's happening elsewhere.
We have breaking news from the Supreme Court. Anna is taking a look at it.
Yes, come back to me, please,
yes,
because
and
I
we
haven't
will,
had a
we will
chance to read
discuss
that.
it at the bottom of the show to give her a little bit of time to familiarize herself with the situation. All right. while we're on the subject of firing all the workforce of the federal government, let's talk about agency dismantling as well, James. What do we have going on there?
Me myself, a couple of cases in the agency dismantling front. One, similar to the first of the two, of the personnel we just talked about, which is essentially the government going to the Supreme Court. This is in the McMahon versus New York case out of the District of Massachusetts. This was an effort very similar in terms of the reductions in force. What happened here were firings of, I think, nearly 1,400 individuals through a reduction in force. And that was then challenged in the District of Massachusetts, which granted a TRO, a preliminary injunction. The First Circuit upheld that. The government has now gone again to the Supreme Court here, arguing a couple of different things, very similar to the arguments that we saw in the case out of the Ninth Circuit just discussed, essentially that this should be in the MSPB system, not in front of a federal district court, and that in addition, the types of reductions in force that have been ordered here are entirely permissible. One other point, which is maybe sort of a categoric kind of, what category or box we put this in. The way the plaintiffs have litigated this case is very much the way we actually just teed it up here, which is an agency dismantling case. That in essence, these firings were done in a larger effort to try to make the Department of Education go away, which of course Trump has not been shy in saying that's exactly what he'd like to do, with a sort of tack on to the extent that's permissible under applicable law. What the government has argued here is, yes, it's true there have been nearly 1,400 firings, but there still remains some 2,000 individuals at the Department of Education. That's still consistent with the government's view of what is statutorily required to keep an operating Department of Education, and that is also within the wide discretion of the executive branch and the president in deciding how he needs to, or the government as a whole needs to operate an education department. So that was just filed today. And out of the First Circuit, Justice Jackson ordered a response a week from today. So we'll see a response from the plaintiffs at some point next week. The other case in the agency dismantling realm that's worth a quick comment is Aviel versus Gore. This is another case that we've been litigating for quite a long time. This is the firing of the CEO of the Inter-American Foundation. For those who may remember Pete Morocco, I think some of the reporting suggested he was placed on the board by President Trump, and then immediately started firing people, including the CEO, Sarah Aviel, who then challenged it. Aviel had a successful challenge in the district court. This went up to the DC Circuit, and we had an interesting ruling from the DC Circuit this week. Interesting insofar as the panel is one that we've seen. I don't think it's any more the motions panel for June, but was for last month, May, which is Judges Pillard, Katsas, and Rao. We'd often see the more conservative Republican-appointed judges, Katsas and Rao, ruling in favor of the government. That is not what we saw here. We saw Judges Pillard and Katsas essentially holding that the district court was correct in both that Morocco didn't have the authority, neither the president nor Morocco had the authority to remove the CEO, and that reinstatement to her position was in fact permissible. Judge Katsas, you kind of get the sense he was holding his nose to reach this, because he says something like, it's permissible under the en banc court's recent decision 3 weeks ago in Wilcox, from which he dissented. I thought it is sort of an admirable acknowledgement that he is bound by circuit. I shouldn't say bound by, but in a stay posture. He said, look, we're engaged in stay litigation here. The en banc court addressed a similar reinstatement question in a stay posture there. We should draw, we should weight that heavily in our thinking. So long story short, the CEO of the Inter-American Foundation lives to fight another day.
All right. It is time for the three-letter initials lightning round. Let's go through a whole string of immigration cases. The first one of which, of course, does not involve three-letter initials, but Alina Habba has a lawsuit against her. James, what's going on in the great state of New Jersey?
Yeah, this stems out of an incident we've now talked about a couple of different times, and this was the visit by Mayor Ras Baraka, as well as three members of Congress, to Delaney Hall, an immigration facility in New Jersey. As some folks may remember, in the immediate aftermath, there was the arrest of Mayor Baraka. Then that was dismissed. And then there was, as we've spoken about either last week or the week before, the arrest and now the prosecution of one of the members of Congress, Representative McIver, for allegedly assaulting one of the security officials, or one of the, I don't know, security, but one of the federal officials who was there at Delaney Hall. So this is now a federal civil suit brought by Mayor Baraka against Alina Habba and I think Ricky Patel, who was the special agent in charge of the Department of Homeland Security in the relevant region, presumably New York, or excuse me, New Jersey, maybe New York, whatever other area that covers. Essentially arguing malicious prosecution and a defamation claim against Habba, and saying that everything here were just trumped up charges to go after the mayor. There's some disturbing allegations in the complaint. Of course, a complaint is not yet been subject to testing, but essentially suggesting that certainly Habba was just trying to do this the complaint says, in her capacity as a political operative, which is an effort, I take it, to kind of plead around the type of immunity that would otherwise protect a prosecutor. There's both absolute immunity and qualified immunity. I would be shocked if we didn't see motions from both Habba and Patel arguing that they were acting in their capacities as such when they initially kind of had the arrest of or directed the arrest of Baraka. But and so my early prediction is that this lawsuit probably won't go anywhere, but it's a pretty damning indictment in the non-formal sense of the kind of conduct that if true, that Habba and Patel engaged in. The sense was that when Baraka learned that he wasn't allowed to be on the property, he just left. And then he was arrested off the property. That is what the sort of the thrust of this civil suit says. I don't know how much that aligns with the actual facts, but if true, that would be quite disturbing.
All right, Roger, remind us who Arevalo Milan is and what is going on in his case.
Yeah. Darwin Antonio Arevalo Milan. This is a Alien Enemies Act putative class action. And John, I think it's a pretty important ruling. John Holcomb, who's a Trump appointee, he becomes the second judge to uphold the Alien Enemies Act proclamation. And it's actually even more deferential than the first one to Trump's what he puts in the proclamation. Interestingly, despite that, he does enter a class-wide injunction against removal because of the due process issues. The government would not commit to him basically to anything other than to say, we'll give them more than 24 hours notice, but we won't tell you how much more. And so he didn't enter the class-wide injunction. This is the Central District of California, which, despite its name, as most of you know, is really more like Los Angeles. And east of it, the Mojave Desert. This involves a guy in the facility in Desert View. The thing that's, like two of the other Trump judges who reached other results had said you can't dispute the fact finding in the proclamation, but you can dispute the legal conclusions he draws from those. So, for instance, when he says that Tren de Aragua is directed by Maduro, you have to accept that. You can't put in affidavits that dispute that. So they accept the idea that Tren de Aragua is the same as Venezuela. But you still have, the other judges still evaluated whether this was an invasion or a predatory incursion. He says you can't even do that. It leaves up to the president both the legal conclusions, the findings and the factual findings and the legal conclusions. So I think that's a pretty important decision.
Yeah, that has
And
I would say,
unfortunately, it's not
zero
absurd.
chance of survival at the Ninth Circuit, but not zero chance of survival at the Supreme Court.
Exactly.
All right, let's talk about DVD and all its subcomponents. What's going on there?
Well, one thing that happened, and is that yesterday, I think one of the defendant filed an affidavit. Remember that we have these 6 very serious criminal aliens that are now sort of stranded in Djibouti. They were headed for South Sudan, and Judge Brian Murphy stopped that. And then he said, look, you need to provide them a reasonable fear interview, make sure that and where you do it is up to you. You can bring them back, you can do it there. If you can do it there. And actually, there was a lot of back and forth where the ICE guy, he was asking the ICE guy, do you have facilities to do it there? And finally, he said, yes, we can do it there. So they're doing it there. And here in this affidavit, there's a very sort of nasty thing about they're in danger of getting malaria. They're in danger of attacks from Houthis in Yemen. Everyone is getting sick. And then Chad Mizell retweets or tweets that out and says, look what Judge Murphy is causing these people to go through. Obviously, he isn't causing anything. They could have brought them back in the very beginning. The other thing is that
Wait, can I just say before you move on, Roger, about that?
I'm sorry, you should have done that, but I thought you were reading, so
no, I was reading. I'm still reading about the DOGE stuff. But I just wanted to jump in because I heard you talking about it in the background. On that affidavit, what is interesting about it is that, when Judge Murphy on May 21st or whatever it was initially ordered this remedy, which was, you've got to give these reasonable fear interviews. He basically said during the hearing, I don't care where you do it, but the government was the one who suggested, we could do it where they're at now. Which, they had been kind of sidetracked on their way to South Sudan. And so now they're in Djibouti and they're in this converted shipping container. And as Roger explained, this affidavit explains all the ways that the government is finding it really hard to actually comply with the requirements of the judge's orders, that these people be able to meet with counsel, that they have these interviews, all of that. But one thing I will add about it that's interesting is that, like this declaration was filed after a status report that the judge had required every 7 days had already been filed like 2 or 3 days earlier. And it doesn't really have anything to do with the details of what the status reports required by the judge require. It has all this extraneous information about how ICE officers are getting sick, and they're in close proximity to these people who have been accused of these horrible crimes and all of this stuff. And so it really seems like it is mainly just being used as kind of a PR vehicle, as opposed to having any like real kind of legal significance to it. And it really is interesting because people like Chad Mizell, who's a top official at the DOJ, is going out and tweeting saying, this is the position that the judge put us in. He's risking the lives of ICE agents. But in fact, it was Drew Ensign, the government's own lawyer, who suggested that the most narrowly tailored remedy here would be to allow them to do this in the country that they're in. So it was the government's own suggestion. I just want to make sure we got that point across.
All right. Roger.
And the other tidbits there is that one of the named plaintiffs, OCG, in the original case, who had been improperly, he had withholding of removal to Guatemala, and they just removed him to Mexico with no ability to raise any concerns about persecution or torture, and he had in fact been gang raped in Mexico. He is back in the U.S. We don't know much more than that, but the New York Times has reported, and it was and what I think is they're doing is, this case is now at the Supreme Court, and I think they're cleaning up some of the worst stuff in the background so that they can sort of, yeah, that's been taken care of. Let's focus on jurisdictional issues, and that's been completely briefed at Supreme Court. So I'm actually a little anxious about what happens next there.
Yeah, although I will say, a few weeks ago we had three people who the Supreme Court had removed or who the administration had removed improperly, and there were orders to bring them back. And there was a question about whether there would be able to be compliance with any of those orders. Two of those people are now back in the United States, and that is actually I think, a promising sign from the point of view of compliance with court orders. Although, again, the circumstances of Abrego Garcia's return are, shall we say, peculiar. All right, Roger, we're almost through the parade. Jordan Melgar Salmeron, what's going on there?
This was a story that was broken by the Investigative Post out of Buffalo, a guy named J. Dale Shoemaker. This was a guy that had filed a petition back in 1983. And it's actually in front of the Second Circuit. He's trying to get he's a Salvadoran, and he acknowledges some MS-13 associations back then in the El Salvador, and he's tried to escape. He's disavowed. He's tried to escape the gang. And anyway, he's bringing a CAT claim, a claim under the Convention Against Torture. So he was appealing an adverse administrative ruling to the Second Circuit, and the government all of a sudden on April 17th said, look, if you don't order him, if the court doesn't order a stay of his removal, we're just going to remove him on May 8th. So the Second Circuit on May 7th issued a stay of removal, so it could. And it issued that at 9:52 a.m. and 28 minutes later, he was removed. And so the court has been trying to get to the bottom of that. The government has acknowledged a confluence of administrative errors, and it does sound like that. It sounds, but I won't go into it. It's a pretty interesting story. I might try to write more about. But anyway, exactly what his lawyers are asking for a special master to do fact finding. It's a weird thing when you're at the Second Circuit and there's no district court, because it goes directly from the immigration board, Bureau of Immigration Appeals to the Second Circuit. So we'll have to see what they do.
Finally, JOP, our last three letters this week.
Yeah, so this is the story about Christian, who was sent to CECOT on March 15th with everybody else. In alleged violation of a consent decree, he was part of a class that had been pending in District of Maryland. And couple interesting things here. The Judge Gallagher yesterday ordered discovery, mainly with an eye to pursuing contempt for lack of compliance with her other orders about trying to facilitate his return. And she is a Trump appointee. I think that actually she was a Democrat before she was a Trump appointee, so I'm not exactly sure how that came down. But she had really laced into them. There's a couple things. She had really laced into them on May 28th. She had said, the court finds that defendants utterly disregarded the court's order. Defendants' untimely response is the functional equivalent of "we haven't done anything and don't intend to." Anyway, put that aside. Then on June 2nd, there was this interesting declaration that said that Rubio, it says Rubio is personally handling negotiations with Bukele. He has a personal relationship with President Bukele that dates back about a decade. He has read and understands the court's order and wants to assure the court that he is committed to making prompt and diligent efforts on behalf of the United States to comply with that order. I'm not sure, given what the Supreme Court has said, that might be about all you can, if he says that, I don't know what you can do. But anyway, that's a possibly important development.
All right. It is time for breaking DOGE news. And here it is. There is WITAOD merch, people. Anna, tell us about the WITAOD merch, which is now available.
We have merch on, I believe the name is lawfarestore.com.
TheLawfareStore.com.
The Lawfare Store. Is that right? Okay.
Yeah.
TheLawfareStore.com. We have our phase 1 merch drop for the long-awaited WITAOD merch. We have 2 different types of hats.
Hang on, we're going to share the screen so that everybody can see the hats.
There was a bitter division within the Lawfare team about whether there should be a question mark or multiple question marks or just one question mark on these WITAOD hats. I know that a lot of people wanted an unhinged level of question marks, and I promise in future merch drops, there will be content that includes multiple question marks, but in this case for a hat, it was kind of off-centered if you had a bunch of question marks. So
I want to point out that for those who are truly bold, there is it doesn't look like it will display it, but you can get these in MAGA colors for those who are truly willing to oh, did it not share the screen?
It did for me.
Oh, okay. Did it go away?
no, it's still there.
It's
All right.
still up.
Well, I don't know how to turn it off. For those who are truly bold and who want to be offend people, go with the ones with the MAGA colors. We will be doing more WITAOD merch as well as other important offerings very soon. All right. Anna, what is the real breaking WITAOD news in the Supreme Court?
Yeah, so the real breaking news, we've talked before about Cruz's suit against DOGE, trying to argue that DOGE or the United States Digital Service is subject to FOIA. The government has argued that the United States Digital Service is not subject to FOIA because it is a component of the executive office of the president, and that it is merely just an advisory body, and traditionally advisors of the president or advisory bodies within the executive office of the president would not be subject to FOIA. But that question hinges on this factor of, determining whether or not DOGE or the United States Digital Service exercises substantial independent authority separate from the president. And so in this suit, at one point, Judge Christopher Cooper in the district court in DC issued a discovery order granting discovery to Crew on a number of preliminary questions around these factual issues about whether or not the United States DOGE service actually does wield substantial independent authority. One of the things in that discovery order related to requiring the United States DOGE service to respond with any recommendations that it has made to federal agencies, and whether or not those recommendations were followed. The reason that the plaintiffs wanted this and that the judge granted it is because, of course, there's this kind of debate about whether or not DOGE really is advising or if it's directing. And Judge Cooper recognized that there's a very fine line between recommendations and directions. And so this is one reason why he granted this request. This discovery order also would require Amy Gleason, the alleged acting administrator of DOGE, to sit for a deposition, and it would require some other things. The government appealed. They argued that this is a separation of powers issue. They argued that they shouldn't have to disclose these recommendations because, a recommendation doesn't necessarily have to be followed. The DC Circuit said, nope, we're not going to stay, eventually said, nope, we're not going to stay this after there was an administrative stay. The reason being that the government did not object on the separation of powers grounds that it eventually brought when it appealed or sought a writ of mandamus. So basically they had waived that objection. Then it went up to the Supreme Court and the court issued an administrative stay. And then now the breaking news this afternoon is that the court, in an apparent 6-3 decision, has granted the government's application to stay the discovery order. Ben, they found that, and the three justices who dissent are the liberal justices. But the court finds in this order that the case should be remanded back to the Court of Appeals for further look. It says that the portions of the district court's April 15th discovery order that require the government to disclose the content of intra-executive branch USDS recommendations and whether those recommendations were followed are not appropriately tailored. The reason why the court says is because whether an entity is an agency for the purposes of the Freedom of Information Act can't turn on an entity's ability to persuade. Furthermore, separation of powers concerns counsel judicial deference and restraint in the context of discovery regarding internal executive branch communications. So now this is supposed to go back to the lower courts. I need to look at this a little bit more and compare it to the original discovery order. But it seems to me that because the focus is primarily on the part of the discovery order that relates to the disclosure of these recommendations, that once it's sent back down, there still may be things related to discovery that can still go ahead, that were included in Judge Cooper's order. I also have some questions here about how this will play out, because the court is talking specifically about the United States DOGE service, which is in the executive office of the president. But if you look back at Judge Cooper's order, it had requirements about not just the United States DOGE service, but any DOGE team members who are embedded in agencies and what recommendations they made to their own agency. And of course, the government's line has been in other cases that those DOGE team members are not actually a part of the United States DOGE service. They are apparently a part of the agencies themselves. So there's a lot of different, nuances that may be worked out as it goes back to the lower courts. But for now, Amy Gleason's deposition apparently will not go ahead.
All right, we have another Supreme Court DOGE ruling as well, right?
I have been focusing on this Supreme Court DOGE ruling. So unfortunately, I have not gotten through the other Supreme Court DOGE ruling. I do believe that it relates to the Social Security Administration case, but I'm not sure if James or Roger have had a chance to look at that. If we are able to come back to it in a few minutes, though, I can
okay.
update.
Okay. Have either of you taken a look at this?
I have not yet. I was looking at the one Anna was looking at as well.
All right. No worries. We will we'll talk about it next week. If there's a Supreme Court memo to the Supreme Court, stop dropping these while we're working on these things.
But if Roger and James, if you have anything to add on what I mentioned in terms of the
actually, even if they do, we need to move on because we are running out of time. And we would not be it would not be sporting of us to leave the Trump-Musk feud without asking Anna Bauer. Anna, can we now exclude Elon Musk as the administrator of DOGE as a suspect?
I think we can, unless you are one of the people who adheres to the galaxy brain theory that this is all a ruse and that it's a fake fight, a way to throw the courts and also maybe me off the scent of who really is the administrator of DOGE.
I think we're gonna call that a yes. All right, we're gonna go to audience questions. Josh asks, what is the status of the two E. Jean Carroll v. DJT cases? If one of us is going to know that, it's going to be Roger. I haven't kept up with it the last few weeks. Roger, do you have any information on that?
One was upheld by the Second Circuit. It was unanimous. I don't know if they're trying en banc or not. That would be. But the other one
which is the big one.
The other one, yeah, the big verdict. They raised belatedly. It's hinging on either, I think, on either a late presidential immunity ruling, whether that was decided, or yes, I think there was a late presidential immunity claim, and they need to litigate that now. And I'm sorry, it is a blur.
All right. Mike asks, aside from the question of Abrego Garcia's guilt under the indictment, what is the possibility that Judge Sines will make one or more findings of contempt? So there is obviously a contempt question. Um, but it is much harder to argue that somebody is in contempt when he has been returned to the country and there is a notification of compliance, which I understand has just been filed. And um, so the question would, there was no specific deadline for his return. And the government does seem to have complied in the sense that he's back in the country, or he will be, assuming they get him from El Salvador. So I don't know what the basis for contempt would be unless there are specific interstitial rulings that were not complied with. Generally speaking, Judge Sines can probably congratulate herself for having effectuated one way or another, for good or for bad, Abrego Garcia's return to the United States. And I doubt you will see a contempt finding. It's not like Judge Boasberg, where in the broad scheme of things, her order was defied. Her order was foot-draggingly and weirdly complied with. Do any of the three of you disagree with that?
My silence is not no noted dissent.
Well put. I mean, I don't say that with any sense that the government has not shrouded itself with glory in this case. But if you're Judge Sines and you look at it and you say, which of my orders was defied? The big one was you got to do what you can to bring him back. And they did something and they kind of brought him back belatedly, foot-draggingly, resentfully, and with a lot of really contumacious behavior, including by the president. But at the end of the day, the order didn't say the president can't be a flamboyant asshole in the White House. Um, all right. Catherine Watkins asks, what does James think about Judge Dugan's motion to dismiss based on her immunity for official acts in her courtroom, which she says is similar to the immunity that SCOTUS gave to Trump? So James has addressed this before, but let's turn it over to him again.
Yeah, I wrote a short piece for Lawfare on this. I also spoke about it a few weeks ago when we sort of first saw the motion, and then wrote a piece where basically I said I don't think very much of it. I don't think courts have recognized any kind of an immunity from criminal prosecution for judges. The sole outlier that I am aware of was a district court case from a prosecution actually involving, among other people, Charlie Chaplin, which is sort of an interesting historical anecdote. But the upshot of the court's analysis, the district court's analysis there, was a lot of skepticism about the prosecution, and the merits of bringing a prosecution seemed to bleed over into the judge's thinking about the immunity issue, which I thought was mistaken. All of that said, I did note that at some point last week, so I when I wrote the piece and when we spoke about this last on Lawfare Live, Dugan had filed like a 7 or 8 page motion to dismiss. Her lawyers have since filed a much more comprehensive, about 30 or 35 page motion that makes a slightly more sophisticated argument and relies, as I think the question suggests, much more heavily on kind of the Trump v. United States methodology, and says, well, for official acts in my official capacity, I should have immunity, and tries to distinguish away a handful of cases where judges engaged in bribery or corruption for official acts, right? So they took bribes to issue reduced sentences or to decide cases in certain ways. So I think that's a better effort to articulate from kind of relying on Trump. I think Trump was wrongly decided. I also think, even if you don't agree with me, it was very much this is a free pass for presidents, but nothing to suggest it should more broadly apply outside of that to judges or to others. So I may do a sort of a follow-up piece on what I think is a better articulation of Dugan's argument in her longer motion to dismiss, but I still come down where I did in the shorter piece and in speaking about it before, which is it's not one that courts have recognized, and I think for good reason.
All right, last question from Andrew. Enrique Tarrio and a handful of other Proud Boys, including one John Doe, brought a Bivens action this afternoon in the Middle District of Florida, seeking $100 million in punitive damages. This case can't be very likely to prevail, but could we see a settlement akin to the one we saw with Ashley Babbitt's family for $5 million? Also, the attorney who signed the complaint is named Augustus Sol Invictus, and he is a recently convicted felon in Virginia. So just to be clear, I know nothing about Augustus Sol Invictus and whatever criminal record he may or may not have, although I do love the name Augustus Sol Invictus, Augustus being, of course, a reference to Caesar Augustus, and Sol Invictus being a reference to the god of the unconquered sun.
But okay, but to be clear, his real name is like Andrew Gillespie or something.
Yeah, but I think we got to get, when someone's going to show up on our show named Augustus Sol Invictus, we got to spend a moment with that because that's kind of awesome.
And his law firm is named the Invictus Law Firm, of course.
That's great. That's great. Well, good old Sol Invictus. Look, this is a good scheme, honestly, because in fact, the government has unrestricted authority to settle cases. The case against Ashley Babbitt is, you know, there was there was no plausible way she was going to prevail in that case, nor was that case worth $5 million to settle to the government, unless the goal was to reward the family of somebody in January 6th, just as pardons were benefiting families, people involved in January 6th. And so if the question is, if the Justice Department decides under its new anti-weaponization leadership, Eagle Ed Martin, that it wants to put money in the hands of Enrique Tarrio's family, individual, as well as it can settle the case on whatever basis it wants. And so, look, if you're a MAGA person, their slogan right now is "No MAGA Left Behind." That's what Ed Martin literally says. And so if you have even a ridiculous claim represented by Augustus Sol Invictus against the federal government on behalf of criminal activity that you engaged in for Donald Trump, it's a good time to stake your claim. I mean, it's like a kind of homesteading, I think. What do you guys think?
I agree. There's no punitive damages in a federal tort claim act, and there's no prejudgment interest. So in a real life case, it's very hard to get much money. But if Ashley Babbitt is getting $5 million, then there's no, this seems like a collusive suit, and I guess they just have to make a judgment about if they give him a big reward, those guys a big reward, where does it stop? How much do you give the 1,600 others?
No, I think that's right, but I think you will start to see. I mean, they're going to have to make a threshold judgment. Do they want to? And he's sometimes talked about, compensating, right? Do they want to do that? And if they do, there's really very little to stop them. I mean, Congress cannot, I don't think you'll see Congress pass a 9/11 compensation like scheme for it. So you have to do it through individual settlements, but you can. And, I think some of them are, the restraint on this is that it's not likely to be particularly politically popular. And, it's one thing to pardon criminals, it's another thing to pay them.
Oh, the other thing is I see somebody mentioning that this is a Bivens action. I don't think, anyone is won a Bivens action outside of Fourth Amendment claims in,
Since Bivens.
yeah. Yeah.
All right. We are going to leave it there. We're going to end on time. Buy your WITAOD hats. Tweet your WITAOD hats or blue sky your WITAOD hats at Anna Bauer. Make her regret that we ever did this. We're going to be back next week. A quick programming announcement in response to a lot of comments from you guys. We think, a new concept or a concept for how we're going to refine this Lawfare Live, which is, generally speaking, we're going to keep things as they are. We are going to, when we need surge capacity and we have too much stuff to do in a single week, we're going to do an extra episode on Tuesdays. We may not do them on any given week, but when we surge, we will surge on Tuesdays if we possibly can. All episodes will go on the podcast feed. We are going to restrict questions in the regular episodes to 4. And we are going to have monthly AMA episodes like the ones we had this week that will be purely devoted to questions. And as to what time on Tuesday, we don't know yet. We haven't decided that. All right. See you next week.